I'm not happy with you, Mr. Shelby. Why am I not happy with you? Therein lies the problem. You don't even know what kind of bond conditions you have, and it's your second bond violation. What, am I supposed to let you go again? No, I'm not going to do that. We asked you, and you have a very serious case. We asked you to conform with these bond conditions, and you can't, and you have not. So what am I supposed to do?
His thing has been charged since I spoke to him. When did I first speak to you? After?
Today.
No, I spoke to you like right after Thanksgiving and told you you had to keep your ankle monitor charged, didn't I?
Yes,
Has it
ma'am.
been charged since then?
Yes, ma'am.
Why wasn't it charged on the 24th of November? Are you homeless?
No.
Do you have access to an outlet?
Yes, ma'am.
Then why wasn't it charged on the 24th of November?
I was late.
Late where?
Felicia,
Yes, Judge.
is this device operational right now?
Yes, it's operational right now, but it just keeps hitting 1%. And it states here from our case manager that we've like over and over again repeated to charge the device. But it keeps hitting 1% consistently. I see tons of notifications here where it's charge device, charge device, charge device, please charge your device. Come to the office if you're having issues, charge your device. They're quite expensive.
Yeah, I don't know what to tell you, but you're not complying with the bond conditions, Mr. Shelby. I let you out of jail. I asked you to do one thing and you're not doing it. You've already failed me once. Am I supposed to let you go again?
Yes, sir. Yeah.
No, that's not the right answer. You're not charging your device. It goes with you. John.
Judge, may I bring up Mr. Celestino and his mom, Judge? This is an off docket. This is the one that you told us we can come back this week. He's the one that you put a curfew, and he works during the curfew hours. Hold on before you can just come up.
He's already, it's okay, come on up. Mama.
Judge, we have an interpreter here because she doesn't.
That's okay.
Judge, I asked mom to come because, she knows about his work schedule. He's talked to his supervisor. They just don't have any other time slots for him to work except for the second shift, which is from 3 in the afternoon until sometimes 2 or 3 at night. And I've talked to mom. She's assured me that that's where he is. That's where he works. She can vouch for it. She can help monitor. But he just needs to get back to work. They rely on somebody.
What is your cause number? Do you mind?
Oh, yes, I'm sorry, Judge. It is 251.
Okay.
7372, Judge.
Thank you so much for coming. Mom, thank you for coming. The problem I have is that he's charged with a very serious offense. He's young. And while he's on bond for this case, he's continued to mess up. It's not the first time I've brought him back here for violating conditions of his bond. He has had bond violations in that he's continuing to mess up. And it scares me to let a 17-year-old out at 3 in the morning. Because I don't know what's going on at 3 in the morning, and it's hard for me to monitor. So how do I know he's not going to be out there consuming alcohol at 3 in the morning? That's what scares me.
I'm finished talking to your mom.
So a lot of people tell me that they're doing one thing, and then when they leave and they go out the doors, they do something completely different. And so that's why it scares me. What he's charged with, He's continued to have violations while he's on bond. And now he wants me to let him out at 3 a.m. I understand he's saying he's working, but
Él tiene que pagar biles
He has bills to pay.
y yo voy a estar monitoreándolo. Él sale a las 3
I'll be monitoring him.
de la tarde y sale a las 2 de la mañana.
He leaves at 3 p.m. and finishes at 2 a.m.
Yo entro a mi trabajo a las 3 de la mañana y salgo a las 2 de la tarde. Yo lo
I
llevo al
go to my work
trabajo
at 3 a.m. and finish at 2, so I take him to work.
y alguien, yo hablo con su compañero del trabajo y él me trae a esa hora.
And I speak with a coworker of his that then brings him back home.
Y él no se va a ir para ningún lado porque yo hablo con el muchacho que lo lleva a la casa y me dice que él ya está ahí en la casa. Que va para otro lado más
He
que
won't go anywhere else. I speak with his coworker and he lets me know whenever he's brought him home. And he won't go anywhere else.
Ms. Siegler, are you familiar with this? Can I? What?
Probably not familiar with it.
Right. So what we have here is we have a young 17-year-old with the DWI, right? He's on bond. The case is old. I mean, what are we doing anyways?
The problem is, he's a .18, and we're trying to get all the mitigation stuff in. I think.
He's a .18 and he's a 17-year-old?
And so we gotta get that mitigation in. You won't accept the time served, so it's not a mitigation or probation, so I'm trying to get that in as fast as I can. Nathan has already told me that there's already a clicking clock, so I'm trying to get that ASAP. I turn them around fast.
I don't want to be blamed for not taking a time served. If he wants to take a time served, then he can take a time served. But you need to understand is that when you plead guilty, it stays with you for the rest of your life.
I will explain that.
I never think it's a good idea at 17-year-old to potentially shut a door when you have the ability, if you're granted entry into this program, to try to get this dismissed. A lot of people take a half-assed approach to things in life. When you take a half-assed approach, you get that same kind of result.
So you say it's a program?
When you plead guilty to an offense, you can never undo that. You're stuck with it for the rest of your life. And when you get a conviction on your record, it's going to hurt you. So
I'm basing that on what a pretty much state standard rec on a first time DWI check. And, there's only 3 options. There's time served, there's probation, there's PTI. PTI clock is running not only because the case is getting older, it's because I haven't been telling. So we did that done within the last week, within the next couple of weeks. If that's gonna be around. Now, I haven't talked to him about the other one. You just did, because when I talked to you before, you indicated to me that you were able to go down that path. So that maybe this is new news that you're reconsidering, and if that's the case, I'll certainly talk to him.
look, they have this program. It's a diversion program. If you're granted entry into it and you complete it successfully, the case gets dismissed. Your case is old and it's time to make a decision. If you want to do it, then that's what you got to do. If you want to take the easy way out, I'm happy that you can do that as well. It's up to you guys, but you need to make a decision. The reason we're here now is because he wants to be out in the middle of the night working, right? But, it's a DWI and we have a positive blow, or we have a 2 weeks ago. Was he working in the middle of the night?
He's been working. He's been working. I mean, in that particular incident, Judge, I don't know, but he's been working for a while. So, and I think he mentioned to me that it was a really bad choice when you were at a family gathering. Is that right? It was like, it wasn't at night, it was during the day when that happened.
And then Judge, after when I got out of custody, the same day I got out, I went to work, then went to work Saturday, and Sundays I don't work.
What does he have on him now? Does he have anything on him now, a scram?
Yeah.
Yeah, you put an ankle monitor. The problem is that the
How's he
scram-
The last name, sorry.
Celestino.
I have to get, it's not on docket, I have to get to give you a cause number.
He does, as part of his new bond condition, when he got out, he's on a.
Yes.
251 7372.
Yes, I have a GPS device with that curfew and then a scram device as of the.
Has he been good on the scram?
I believe so, but let me just double check.
Okay, here's what I'm gonna do. Assuming he's negative, I mean, what are your thoughts?
I think that we definitely would want to keep them on the scram and the GPS.
Well, that goes up, of course, but I mean, as far as letting him out at 3 in, working, what time did you want to work?
The shift I'm in is from 3 p.m. to 2 a.m. And then the other shift, which is day shift, it would be from 4 a.m. to 2 p.m.
So which shift are you planning on working?
I'm trying to stay at night shift so I could go to college starting January.
So which shift do you want to work?
Night shift.
So is it the 4 a.m. to, or is it
This
this,
is 3 p.m. to 2 a.m.
say it again?
3 p.m. to 2 a.m.
That's the shift that you want to do?
That's the one he's currently.
Judge, I'm reaching out right now to
January
get an updated compliance check due to the holidays. I just don't see an update on it. For the scram report, somebody should get it back to me very shortly.
So let's do this. I will allow you to work, but if I find any other issues, then I'm gonna take you off. And you don't have all night. No, it's you from 3 p.m. until 3 a.m. is when you have to be home. Do you understand?
Sir.
If you're out at 4 in the morning, if you're out at 5 in the morning, if you test positive for anything, it's not gonna go well. Do you understand?
Sir.
Number one. Number two, I'm giving you 2 weeks to get all the documents ready for this program. Your case is old and it's time to do something now. So
I just want to let you know that the case was reset till the 9th of January already. That's the reset you gave them before. And this is an off docket, just to try to clear up the curfew. I mean, that's reasonable because I think the program, according to my intel, we got to get that in within the next couple of weeks anyway. I just didn't know whether or not you wanted him to come back to it. Or reset it.
well, yeah, because he needs to do a TRAS regardless. So I guess let's do this. I'm not gonna set it all the way up to January 9th because it's old. I'll give you the 4 weeks, John. But at that time, when he comes back, we need to have a decision made as to whether he wants to get into this program to get into the diversion. If he does, he has to have all documents in by the next setting.
Well, absolutely.
And then we'll send him to go get a TRAS done at that time. Don't drink alcohol. And if you don't have a license, do not drive. Do you understand?
Sir.
If you fail me again, it's really not going to go well. Do not use alcohol. He's not driving, is he? Or is he driving? Do you have a Texas driver license?
Yeah, I did. And then at the time of the DWI, I had insurance too.
¿Tiene aseguranza ahora?
Ya.
Ok. No puede manejar sin licencia, sin aseguranza. All right. Ok. Si él tiene un positivo de nuevo, lo voy a encerrar. No me importa la excusa. Ok. A las 3 de la mañana en la casa. Okay? All right.
Just we'll bring it back on the 31st.
Okay. Done. But everything,
Got it.
all right. Okay, Mr. Celestino.
Here's what's happening legally. Once a facility revokes your right to be on the property, even if you've been a patient for years, refusing to leave turns into criminal trespass instantly. And now the judge has to untangle whether he can visit other doctors in the same building. Complicated? Yes. But this is a perfect example of how one
Your bond. Do you understand? The next time, triple, if not quadruple, if you violate conditions again, I will not allow you to continue to endanger my public. Do you understand, Mr. Gonzalez? No consuming alcohol or dope, and no more driving. You pick up a third case, holy moly. So where are we as far as, you said community service and what else? How much is restitution?
$1,000.
$1,000.
Yes, sir.
Have you spoken to see how long it will take to get the $1,000?
I have spoken with him, Your Honor. He has a job at a tire shop that he works on the weekends when he's out of school.
Someone's got money because they just posted a 2004 bond for you. So I don't want any more issues. Do you understand? I'm sending you for a drug and alcohol test today. And I'm now going to also give you a curfew. I don't want you out in the middle of the night. Then I'm going to put a GPS monitor on your ankle so I know that you're not messing around and not screwing up. Do you understand?
So,
Okay. All right. Okay, Sonia, we'll give you a normal reset, but curfew from 9 p.m. to 6 a.m. No drugs, no alcohol. And what are you in school? What are you doing with yourself these days?
I'm fixing to graduate on December.
It would really be a shame to really waste your life away because of this. I'm going to tell you that if you ever want a good job in life, if you ever want to do something meaningful in your life, racking up criminal cases is just continually to shoot yourself in the foot. Life doesn't get easier when the older you get. It becomes more difficult. You get bigger, fatter, uglier, you lose hair. Life doesn't get easier. It gets more difficult. And the more convictions you rack up, all you're doing is you make yourself unemployable. At some point, if you really want to make a difference in this life, you do it with education, not what you're doing now. You graduate from high school, you go to college. The more knowledge you have in this life, the more money you're going to make. And the more money you make, the happier most times life is. Do you understand? That's what life's about, making a lot of money and doing great things, not racking up convictions and being back in jail over and over. But if you test positive or you pick up a new case, I'm gonna go nuts. Do you understand? Okay, man. All right, son. Thanks. You Perez Gabriel?
Sir,
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Okay.
On November 21st, 2024, officers were informed of a street takeover set to take place at a restaurant depot parking lot located in Harris County, Texas. The officers conducted surveillance of the location in an undercover capacity and observed the defendant's motor vehicle enter the pit and conduct 15 to 20 donuts. The vehicle got within 10 to 20 feet of several parked occupied vehicles, and there were approximately 100 vehicles in the parking lot. The officer conducted a traffic stop on the defendant's vehicle after this incident, and upon contact, the defendant admitted to performing donuts in the parking lot.
Got it. Mr. Perez, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir?
sir,
How old are you, sir?
19.
You are not allowed to participate in this kind of behavior again. And if I find that you do, the first thing I'm going to do is I will put you in jail. The next thing I will take your ability to drive away from you. Living in a city as big as Houston without the ability to drive blows. Trust me. Don't do it. There are other places in Houston that you can partake in this type of action, not in the public. District attorneys have full power to seize and take cars from individuals who participate in this kind of behavior, and our legislature has made it very easy for them to seize and take cars from people who do this, and I've seen them do it. You like your car, they'll take it from you. So be careful how you behave. Do you understand?
Sure.
Tell me, what do you do for a living?
Work at a mechanic shop right now.
What kind of money do you make?
600 a week.
What kind of car was he driving, Alex?
The one who was driving. A Ford Mustang.
What year?
It just says a white Ford Mustang.
Can you run his license, please?
Yes, Judge.
Do you have liability insurance in your name?
Sure.
Then you are not allowed to drive.
Sure.
Do you understand? Until I know that you have car insurance, I'm making it a condition of your bond that you're not to drive. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I put someone in jail, not this past weekend, and made their bond extremely high because they violated this very same thing. Do you understand? Did you want to apply for an appointed lawyer, Mr. Perez? Did you want to apply for a court-appointed lawyer?
Sure. Yes, sir.
Okay, we are going to reset your case to give you time to hire a lawyer. I will have you come up here, swear to us that you're not going to drive. If you drove here, you may not drive home. Do you understand?
Sure. Is there any type of course or something I could take? Maybe.
I can't give you legal advice. You need to get a lawyer, and the lawyer can advise you properly. The only thing I'm telling you now is do not drive until you have car insurance and you get approval from us. We'll be signing an affidavit with me today, so heed this warning. You won't get another one.
Sure.
You understand? Come on.
Was that also the state?
No, because I've got the affidavit. Just, you can go. Good morning, Ms. Beck. Ma'am, you're charged with 2 cases. You were charged with theft. You're also charged with unlawful carrying of a weapon. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you, ma'am.
Yes, Judge. The officer initiated a traffic stop in Harris County, Texas, after observing a co-defendant run a red light. When the officer approached, he noticed in plain view on the center console a bag of marijuana. The co-defendant was in the driver's seat and the defendant was the front passenger. The officer observed the defendant was not wearing a seatbelt and the co-defendant provided a false ID and was temporarily detained. During the PC search of the vehicle, the officer located additional marijuana and found unprescribed Adderall inside a fanny pack that the co-defendant had in possession. The officer ran the defendant's information and found she had an active warrant out of Harris County, and the defendant also admitted to having a gun in her purse. The defendant took ownership of the Adderall and marijuana found in the car. And for the theft,
Is she on bond in that case?
I think she's on bond for that one, yes.
No.
Over,
Was she on bond for the theft case and then she picked up a new case?
let me see, Ron.
No, it looks like it was
Doesn't
a
look like it
2B.
was, Your Honor. It was a
Yeah.
2B, Your Honor.
Was there a co-defendant on that, on this first, on the UCW?
Yes, Judge, he has a valid ID in this court.
Okay, what is the is that on today? No.
Or no, I'm sorry, it's on today.
It's on page 23, Judge. Yes.
Okay, so I'm gonna, so no contact with the co-defendant, and then we need to do PC on the theft because we haven't done that. All right,
So for the theft on March 11th, 2024, the officer was dispatched to a theft at a Walmart in Harris County, Texas. The officer made contact with the complainant, the loss prevention officer, who stated the defendant entered the business and it was accompanied by another black female. The defendant was observed placing merchandise inside a large bag and using other merchandise to cover the bag from the surveillance camera view as the defendant continued to conceal merchandise inside the bag. When the defendant was at the cashier checkout, the defendant was observed scanning some items at the checkout, but did not scan all of the merchandise. The defendant then walked past all points of sale without attempt to purchase further merchandise. The defendant was stopped, where the defendant was asked to return the merchandise, and the total was $121.31.
Got it. All right, Ms. Beck, I'm gonna find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to go to any Walmart. Do you understand?
Yes.
I'm also ordering you not to be in possession of any weapons. If I find that you violate either of these conditions, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, man?
Yes.
What do you do for a living?
I work in a school. I work in a school.
The second degree felony that she picked up, the 4 to 200, was that the Adderall case?
Yes, Your Honor.
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using likewise, I will put you in jail. No more PR bonds. Do you understand?
Yes.
Do you have an income? How do you support yourself, man?
I work and I go to school to be a surgical tech.
So do you have an income? What kind of money do you make a month?
3,500.
Okay, we're going to reset your case to give you time to hire a lawyer. I'm going to first have you go to Victoria, sign a reset. After that, you'll get with police your free bond conditions, and after that, you're free to go. You already have 3 open cases. You pick up another one, it's really not going to go well, man. Just don't go to Walmart, don't use, and don't have any weapons. Did you guys want to add?
Your Honor, I was just wondering, are these state's conditions?
No, I'm going to have her monitored because she has the open,
Yes.
ECS, so I'm ordering her not to use.
Yes, Judge.
So don't worry about it. So did you get it? No contact with the co-defendant?
No contact, no Walmarts, no drugs, alcohol, right?
Yeah. All right. All right, Ms. Beck, good luck.
This way. Judge,
You are Alex Rojas. Mr. Rojas, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are in a common law marriage, and on August 26, 2024, the officer responded to a family disturbance. The complainant and the defendant were in a verbal argument because the defendant accused her of cheating, and the defendant pushed her on the left rib area, causing her to fall and causing pain to her left rib area. The defendant then retrieved a bottle of bleach and sprayed bleach on her several items, causing it to get on her face, shirt, and right arm, causing a painful burning sensation. The defendant then pushed her once more, causing her to hit her head against the door frame, causing pain and a laceration. The defendant then bit the complainant's right arm with his teeth.
Mr. Rojas, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. I would suggest that you get to know it. If you violate the protective order, it's very possible the state files an additional case against you, a violation of a protective order, and that is the capital murder of misdemeanors. You pick up a VPO, things will go sideways real quick. Do you understand? No contact means no contact in any way, and that's what I'm ordering you now. Don't be in possession of any weapons, and you shouldn't have weapons as it is. Do you understand? We're going to reset your case to give you time to hire a lawyer, so I'll have you sign a reset with Victoria. I'm going to have you take a seat in the jury box, so we'll get your bond conditions, we'll have you sign it, and then you'll be free to go.
Can I apply for a court appointment?
What do you do for a living?
I'm unemployed right now. I lost my job like 3 months ago.
Why?
Because they had shut down the company that I was working with.
So how are you eating now? How do you get money?
What I can on the side, cut yards, pressure wash, whatever comes up, but I don't think it's gonna be enough for a lawyer. I'm staying.
When are you going to get a job? I mean, have you not?
Fine. I'm just waiting to see if I get a call back from somebody.
All right, I'll have you fill out an application. I'll take a look at it. Mr. Rojas, heed this warning. Don't have any contact with this person. You understand? All right, please.
Yes, sir.
This way.
Roland, Bristol, page 34. Go ahead and sign it, please.
Is it Crystal Rollins?
Rollins, yes.
Ma'am, you charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On November 20th, 2024, the officer was dispatched in regard to an intoxicated driver. The caller stated the defendant's motor vehicle was failing to maintain a single marked lane and almost hit a wall and struck multiple curbs. The caller pursued the vehicle for approximately 5.36 miles before the officers arrived. Upon arrival, the officer made contact with the defendant, who stated she was sorry and advised she did not know where she was. The officer observed the defendant with unsteady balance and appeared disoriented. Standard field sobriety tests were performed, HGN 4 out of 6, and the defendant was unable to follow instructions on the walk and turn and refused to conduct the test. DICs were read but refused. Blood search warrant was signed and executed.
Okay, any priority to be honest?
No, Your Honor.
All right. Ms. Rollins, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
Yes,
Do you have liability insurance in your name?
yes,
Okay. Do you run a license? All right. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. You will not get any more PR bonds. You understand?
yes.
I'm not asking much, just don't consume alcohol, illegal drugs, that's it. Now, I see that you do have a lawyer. Because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but just stay in touch with Ms. Turner and she'll tell you if and when you have to come back to court. For now, we'll just have you sign a reset, get with Fleischer for your bond conditions, and then you're welcome to wait for your lawyer back, okay?
Thank you.
Please.
Right this way. What's the name?
Rollins, top of 34.
Thank you, Judge. Vic Marshall, page 38.
Good morning, Mr. Surovic. So you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 22nd, 2024, officers conducted a traffic stop on the defendant's vehicle after observing it travel at a high rate of speed, 70 to 75 miles per hour in a 35 mile per hour zone. Upon contact with the defendant, the officer noticed the defendant with red watery eyes and an odor of an alcoholic beverage. The officer further saw the defendant was slow to react and was swaying side to side. Standard field sobriety test was performed, HGN 4 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath. The results were .153 and .155.
Got it. Any priority to be honest?
No, Your Honor.
Okay. Mr. Surovic, I'm going to find that there's probable cause to go forward with your case. Does he have a Texas driver license? Alex. Do you have liability insurance in your name?
Sir.
All right, I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Absolutely.
I see that you have a lawyer. Good job on having a lawyer, so I will waive your appearance. You don't have to waste your time coming to court. Just stay in touch with Mr. Nelson, and they'll tell you when you have to come back to court. I'll have you sign a reset with Victoria while we get your, with Fleischer for your bond conditions, and then you're welcome to wait for your lawyer back. All right, please.
Next judge is page 1, Ayala, come on up.
You are Walter Ayala. Do you speak English or no? Okay, Mr. Ayala, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. The officer conducted a traffic stop after the defendant failed to move over or slow down while the officer was conducting a previous traffic stop. While running the defendant's license, the officer found the license was returned if not eligible, and the defendant had a previous conviction of DWI in 2003.
What was the stop?
He failed to move over or slow down while the officer was conducting a traffic stop.
All right, Mr. Ayala, I'm going to find that there's probable cause to go forward with the case. You're not allowed to drive. Do not drive. If you want to drive, go get your license, get liability insurance. But until that point, you will be signing an affidavit with me today promising you're not going to drive. I don't care what your excuse is. Do you understand? We're going to reset your case to give you time to hire a lawyer. So first I'll have you come up here, swear test that you're not going to drive. I'll get you to Victoria, sign a reset, and then you're out of here. When you come back, let's have a lawyer, sir.
Judge, next is page 4, Beck, Brianna.
Come up, Mr. Barahona.
We had the BVR, but looking at the whole case as well, even if he wins the BVR, he still has a case pending. We've worked out a deal on the case where we hope you would accept the plea deal.
Yeah. Is it 30 days? Yes.
I'd like to do that.
You know, the thing that you need to understand is from now on, you won't be with me anymore. You will be in felony court. No matter how old you are, no matter where you go, no matter what you're doing, the only thing that officers look at, they look at you, they smell you, and they look at your record. And if they see anything funky, all you're going to end up doing is in felony court. And if you thought it was bad here, wait till you get to felony court. It doesn't get easier. It only gets worse. And over there, they have a lot more resources than I do, and they can keep you for a long time. So if I were you, even if you've had a sip, I wouldn't get into a car because you're taking a humongous risk and it's not worth it. You understand?
I understand.
The agreement that you guys have worked out is 30 days in jail. You worked out this agreement where, do your time, you get out. This is another proverbial slap on the wrist because it's not like you're doing that much time. But the problem is that you're young. I mean, what are you, 33 now, 35?
27. 27,
and now you have 2 DWIs on your record. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. Shh! If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, there's no going back. Is this what you want to do?
Yes.
You plead to the offense.
Guilty.
I'll find you guilty. He sends you to 30 days in jail. How much credit does he have?
4 days, Judge.
It's 4 days credit. So is he gonna go in now?
Judge, I would request you allow him to turn himself in before 6.
Okay, I'm okay with
Would
it.
you do that? Okay.
But don't use and don't show up late, because if you show up at 6:01, 6:05, they're not gonna take you. And we're gonna have a whole other set of issues. So just remember, don't get into a car. It's not hard,
Yeah.
An Uber, $20, $30, anywhere you wanna go, man. No matter how, start using that. All right. I'm gonna suspend your license for a year. I have to suspend it. I'm gonna do it for a year. Don't drive until you get a license, all right? And then we'll just have you turn in by 6 p.m.
Judge, so he'll turn himself in by 6. The second thing is, would you consider waiving the Supermax fine? I'm appointed on his case.
I get it, but I mean, it's, how do we,
Well, I think one of the options is if he's been appointed, he's been found indigent, so he should be found indigent for the purposes of that also.
I continue to reward Mr. Barahona when he's continued to violate one way or the other.
Well, it's not a reward, Judge. He's indigent. He's indigent. Judge, he qualifies, he's indigent.
Do for a living. You work, you're a painter.
I'm a painter.
Yeah, how much money you make a month?
It depends on the season, you know, from November to February, it's usually very slow and starts to pick up around springtime. And I'm an independent contractor, so it just depends how that year goes for me.
What do you think?
I think it will just defer to the
I'll tell you, Mr. Barahona, you're not gonna see me anymore. You pick up any new cases, you're gonna be up there. All right, I'll wait it. Okay. All right, man. All right, good luck to you, Mr. Barahona.
Thank you.
Hold on. He has an enhancement.
I don't think the enhancement changes the deal though, Judge.
It might be just the prior DWI. That's it, not to make it 90. Is it true that you had a prior DWI in 2019?
Yes.
Okay, true to the enhancement. It's not gonna make it 90.
Right,
Okay,
it's still
all right.
30. Okay.
Okay, good luck, sir.
I spoke with the state. They gotta talk to their chief about whether or not they're gonna dismiss it because they can't talk it out, but she told me to put it on for the end of the week.
Okay.
The state. So are you gonna keep him? Or
Can you bring Mr. Shelby out, please? Lori, if it ever hits 1% again, I'm ordering him as a condition of his bond to have it over 1%. And if I find that it hits 1% again, then I'm gonna take it. And that's it.
he said he was only charging it once a day, and I told him right before he went to bed, and I told him you need to charge it 3 times a day.
I don't know how often you gotta
I
charge.
don't know either, but if I say 3 times a day, it'll be fine.
You only need to charge it once a day for a minimum of an hour to keep it at a good battery percentage. And then if he's having any trouble, he's more than welcome to always go over to pretrial services and we can get it checked out.
Okay.
If it's malfunctioning in some
Well,
sort, but we.
when he
generate
comes
it.
out, tell him. He needs to hear
I can send them over
this.
there, they can re-go over all the instructions.
Okay, I think that would be good.
You need to understand one thing, Mr. Shelby. You don't have anyone that's going to pony up any kind of money to get you out. So when you go to jail, that's where you stay. Do you understand? Yes or no?
Yes, sir, Your Honor.
I am now ordering you to have your ankle monitor over 1% charged. And if it hits a dead battery again, so will your bond. Do you understand?
Yes, sir, Your Honor.
What did I just say?
Keep your charge.
You must charge this thing 1 hour every single day.
Yes, sir.
What did I just say?
Keep your charge every day.
No, that's not what
No,
he said.
not what I said. You have to charge your ankle monitor for 1 hour every single day.
1 hour every single day.
What happens if you don't?
I go to jail.
Amen.
Correct. I will not play this game again. 3 strikes, you're out. And I don't care who is in here arguing on your behalf. I will not play this game with you again.
Yes, sir.
Okay, Lori.
All right. Mr. Shelby?
Yeah. Hey, bud. Did I say it correctly? Is it Cesar?
That's right, Cesar.
Cesar. Mr. Cesar, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
The officer was dispatched to apartments in Harris County, Texas, in response to a known trespasser. The complainant, the property manager, stated that she knows the defendant by sight and that he has been given several trespass warnings. The complainant told the officer that the defendant is not a resident and that he trespasses in vacant apartments. The witness, a security guard, has personally given the defendant the trespass warnings, including on the day before this incident.
Okay. Mr. Cesar, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this apartment complex. Do you understand? If you go back, I will issue a warrant for your arrest. I'm going to put you in jail. I will not give you any more PR bonds.
Oh,
Just, look, you don't have
I
to,
live there with somebody.
unless you're on a lease, they can forbid you from going there.
What about if you get mail there?
I can't give you legal advice. The only thing I'm going to tell you is that they don't want you to go back there. If you're not on a lease, don't go back there. I'm making that a condition of your bond. Let me ask you this. Are you working at this time?
I ain't working.
What do you do with yourself?
I don't work.
How do you support yourself?
Otherwise,
Sorry?
I said other ways. I work like temp services and shit. I mean,
You want to apply for a court-appointed lawyer, sir?
yeah.
All right. I'm going to give you an application. I'm going to have you talk to someone today. They can tell you how to work forward going, but don't go back to this apartment complex. It's just going to go haywire. It's going to go bad. Do you understand?
Yeah.
Okay. He'll give you an application, please. I'm going to have you sign a receipt with Victoria, and then we'll have you take your seat in the jury box, Mr. Cesar. Do you mind filing this?
Whoa, the judge just flipped the switch here. This is the moment the courtroom temperature spikes from mild to boiling. She basically says, rehab, jail, whatever it takes, one more mistake and his freedom is done. This is where repeat offender DWIs get brutally real. Stay with me because what comes next shows
Conditions, please. Hi, Mr. Gutierrez. I want you to understand that I don't like to keep people in jail. Like, I don't get off on it. I want to make sure that things are done, they're done the right way, and that you don't ever come back. The idea is that you learn, and we get you to understand that, number one, when you have court, you got to come back. Number two, when you have bond conditions, you have to comply. And when you don't, there's serious, serious consequences. You and I have been dancing together for at least 2.5 years, and there have been repeated violations over and over and over. And sometimes me, as a judge, I don't know how to go forward. And that is now. I really don't know how to go forward. And the way that I do it is I have you do the TRAS. The TRAS is an evaluation with clinicians to see, these are licensed people. They ask you all kinds of questions to see how we go forward. That's what we did today. We had you do a TRAS because I don't know how to go forward. Do we do SATIP again? Do we do sober court? Do we do inpatient? I don't know. So we got the TRAS done today. Shatori is telling me it should be back within the next 3 days. So we're not going to just we're not going to just hang you to dry and just forget about you. We'll be back later this week and we'll get a good idea of how to go forward. If they recommend sober court, if they recommend SATIP again, I don't know. I will have issue, I'm going to tell you now, if they say sober court, because the problem with sober court, not the problem, the good thing with sober court is that you're out in the free world. But I know when you are out in the free world, you have a tendency to not comply. Therein lies my issue. So if they say sober court, I don't know how we're going to go forward. I don't. So let's see what they say. I want to keep an open mind so that we'll see what they say. Give me questions. Okay, we'll bring you back on Thursday. We'll see what the TRAS says and then we'll go from there. Okay? All right. I just wanted to bring you out so you know exactly what's happening. Okay? That's it. All right. Thank you.
Martinez?
So we'll see you Thursday.
Yes, Judge. Thank you.
Yes, ma'am.
Excuse me.
Yes, thanks. Hey, Morgan. So I'd like to do PC on this case. This is that stash house.
Yes, we're actually talking to Nathan about that right now.
Nathan,
Yes, sir.
this is a very, it's a first for me,
Okay.
a stash house.
Yeah,
Have you seen this before?
I have, but not for a long time.
And I gotta
I'm looking it up right now.
surprised it's not higher up. It's
No,
not
most
like
stash
feds.
houses are misdemeanors. It's strange. Most stash houses are. I teach at the police academy. That's why I know.
Okay, we have to do probable cause, and, you know,
I'm looking it up. I'm gonna try and find the pleading itself right now.
okay.
And tell you-
Are you ready?
I'm ready.
Okay, let's do it. What was his name again?
Sure, so it's called, I think it's Adolfo on there, but it's Anulfo.
That's right. Mr. Martinez, come on up. Okay. Shh. All right, Mr. Martinez, you were charged with operating a stash house. I wanted to make sure that your lawyer was here when we did probable cause. You have the right to remain silent. Anything you say can or will be used against you. Here we go.
Yes, sir. On November 24th, 2024, the officer was dispatched to an apartment in Harris County, Texas. The officer located 5 adult complainants locked in bedroom while conducting welfare check. The officer observed the defendant to be the sole person in the apartment, not locked in the bedroom. The officer determined the apartment to be under the control of the defendant, and all complainants gave similar statements and stated they were held in the locked bedroom without the ability to come and go freely. The complainants were all found to be in possession of identifying documents, but cell phones had been taken away. The complainants stated if they needed to leave the bedroom, they had to knock on the door and be led through the apartment, sometimes with a bag over their head, by one of 2 males in charge. The defendant stated he lives at the location with another male, but does not know the other male very well.
Okay, whoa. So the defendant says that he lives
At the location,
at the location,
but he does not know the second male that also lives at the location.
doesn't know him well, or
Doesn't
doesn't?
know him well.
Okay,
Yes.
all right.
Yes. And the defendant denied knowing the 5 people in the apartment. Instead, they were dropped off in the morning, and that he did not know who dropped them off. The defendant was found with approximately $6,000 on his person, and the officer observed the door where the complainants were to be unable to be locked or unlocked from the inside, only able to be locked from the outside. The room where the complainants were found was free of any furniture, with no mattresses on the floor, and only 3 pillows and multiple blankets. Officers also found a large sheet of plywood covering the window and no working light bulbs. The officer observed a desk in the dining area with 4 envelopes with names in 3,600 written on them containing cash, a total of 11,200. Officers also found a brown wooden baseball bat on the desk with the envelopes.
If I may, Your Honor. So my understanding is that I guess the code says that he has to own the property or rent it, but he was actually renting a room from the guy that lived at that apartment. So he had only paid 1 month of rent to the guy and was going on his second month. He, from my understanding, didn't know who those people were. They had gotten dropped off that morning and he hadn't left for work yet, was my understanding, that day when the officers showed up. And that's all I know from what I gathered. But he had been living there and there hadn't been people there until that morning when they arrived, that the officers then arrived at the home.
Did the officers interview him at all?
Interview the defendant?
Uh-huh.
Yes, Your Honor, and that's whenever he told them that he lived at the location, but did not know the person very well, and that he did not know the 5 people inside. And the officer found them locked in the bedroom, but he denied knowing who they were.
So it says here, person commits an offense if the person knowingly, 1, uses or permits another to use any real estate, building, room, tent, vehicle, boat, or other property owned by the person or under the person's control to commit an offense or to facilitate the commission of an offense under.
Which is, Judge, those other sections are smuggling or trafficking.
Right. Or rents or leases any property to another, intending that the property be used as subdivision 1.
Which would be him allowing them to use the property for such commission of alleged offense, but it wasn't his. I guess my issue is that it wasn't his property. He was not on the renting order.
And Your Honor, the officers found him to be under the property to be under his control, as they found him to be the only person on the premises at that time, not locked in the bedroom. So yeah, that's why it was the officer's conclusion that he was in control of the property at the time.
What evidence do we, Nathan, what evidence do we have that he knows the persons are being trafficked or being held?
Well, in these cases, typically, Judge, somebody's not gonna come out and say, I know everybody's being trafficked in this room. It's gonna be a matter of circumstances, the totality of the circumstances, I would say, to make that out. And I believe, Judge, based upon the information that we have, that we're at least there for probable cause standards.
And if I may, I did go ahead and read the entire DIM summary, and the complaining witnesses that were found in a home did describe 2 individuals, none of which meet the description of my client. They said one of them was a young male with glasses and an older man with a white beard, is what the 2 individuals told the officers.
And Your Honor, in the full DIMS, the complainant one described the.
So hold on a second, because are you telling me that the people who are held captive are saying that it's another 2 people who are acting?
There was, Your Honor, there was a description given, older with gray hair, a round face, and a beard, and the officer observed the description given to fit the physical description of the defendant. So there was a description given by the complainant, and the officer observed it to match the defendant.
Well, but the time he got arrested, he didn't have a beard, so because the mugshot doesn't show a beard, so I would assume. I mean, I would have to see what they said. I just don't think it's.
I think he's there, he's alone, there's $11,000. I mean.
The other thing too is, Judge, it's my understanding, based upon ADA Farmer's recent, I guess, knowledge of the statute, that it's modified to felonies in some cases, which we may be refining this case as a felony. I always try to warn, I'll just say less experienced defense attorneys, when you're dealing with an ultimate probable cause argument, sometimes it comes back worse when you go to the felonies, which I think may happen at that pace, that criminal record that's early.
Be careful what you wish for.
So the statute has changed. I haven't seen what the statute says now, but it.
Are you telling me that it changes? Does it change January 1st?
It looks like there was an amendment in February. It's still in our system, under our pleadings. It's still looking like a class A misdemeanor, but when you read the Texas Penal Code, under section 20.07, it is a third-degree felony, and that was amended in February.
Oh, yeah. Yeah, look at that. Under 2026. All right, so, Mr. Martinez, I am going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to engage in this behavior, not to be in possession of any weapons. If you pick up a new case, if I find you with a weapon, if you engage in this type of behavior, I will put you in jail. I will not give you any more PR bonds. I don't know what your status in this country is, but if you're in this country without permission and you go to jail, and immigration finds you while you are in custody, they will put an immigration detainer on you, and you will be stuck in custody until the case is over with and then shipped off to immigration. You are on notice now that I'm going to do everything in my power to protect my county. I don't care who, what, when, where, but if I find that you're a public danger, then I will put you in custody. Do you understand? You have a lawyer. It is your responsibility to stay in touch with counsel, and they will tell you when you have to come back to court. If they tell me that they are unable to reach you because you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest. No more PR bonds for you, sir. So we'll just have him sign the bond conditions and then he's free to go with you.
Thank you, Judge.
Yes, ma'am. And so for what it's worth, it is now a third-degree felony. So I don't know how it's still a Class A at this moment. So
Correct. Let me,
that is charged as an A versus a third degree.
correct. Let me look into that.
So, yeah, okay. All right, sir. Do not leave, Roberto. If you can tell him, don't leave until he signs bond conditions, please. And then if you can follow those, please.
And just to clarify, no engaging in like behavior and
No weapons, right? Yeah. And no going back to this particular house.
Yeah.
Connor, you ready? Come on. Okay, do you have a plea?
Yes.
I'm ready when you are.
Let's break.
All right, Mr. Sprague, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 12-month deferred. This is the type of probation that if you successfully complete it, you do not end up with a conviction on your record. And I'm going to tell you that this is extremely important for you because this is the type of offense where a second conviction requires a 10-year registration requirement under Chapter 62, which is, you know what I'm talking about?
Yes.
And I'm telling you, when you have to register under this chapter, it is a very, very difficult thing to maintain.
Yes, Judge.
As part of the agreement, you must do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. You will do no drugs, no alcohol, 10 hours of community service, $100 donation to the Houston Area Women's Center, and no threatening, threatening, or abusive contact with
Samaya and Saj.
If you violate this agreement, I will issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out, and we are going to talk about whether you violated this agreement. If you did, you're looking at 180 days in jail. Do you understand?
Yes, Judge.
So you're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you enter into this agreement, you are stuck with us until you complete it or unless you get revoked. The way that you behaved while you were on bond for this case is unacceptable. And if you think that you're going to do the same thing while you're on probation, just got to be careful.
Judge,
Do you understand?
Really quick, on bond, he was compliant. It was, the only reason he missed court was because of my mistake.
But you need to know. I mean, it is your responsibility to also know, right? It's, we rarely close, you know, we're always open like Costco, man, you know?
All right, yes, Judge.
But that's why I'm not putting you into custody now. Otherwise, right, you would be staying with us. What do you do with yourself these days?
Contract work, but since my boss is retiring, I'm actually looking for a steady income instead. So applying for everything.
So are you actually working now as what?
Yeah, just been helping with the fences, most of those fences going down, just building fences.
It's a great occupation. I'll tell you what, fencing, you can make a ton of money. If you do a good job, you put your heart, soul into it, you do well, your name will spread like wildfire. And I'm telling you, building fences, it's crazy expensive. I mean, who knew? Right. So you can, if you do well, you can make a lot of money, you know? So what kind of income do you have now?
At the moment, not too much because my boss is retiring, which is why I was looking for actual steady income, honestly, because my boss was the one that was helping me out a bunch, but he's hitting 75 and he's kind of done with it, you know, so.
Okay, so you can reduce it to the minimum. Okay, so how do you plead to this offense? Guilty or not guilty?
Guilty. I
I will not find you guilty. I'll withhold that for 12 months. If you do well, if you get everything done quick, I'll take you off in half the time as a reward. We want you to do well, and if you do well, get everything done, and you're nice to everybody, I'll take you off in half the time. All right? Okay, man. Good luck to you.
Thank you, Judge.
Thank you, Thomas. Hey, good morning.
Excuse me, you step forward.
Did you say Herrera?
Yes, Judge.
Okay, you're Moises Herrera.
Yes, sir.
Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On November 24th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it stopped at a red light in the opposite lane of traffic. Upon contact with the defendant, the officer observed him to have red, watery eyes, slow, slurred speech, and a strong odor of an alcoholic beverage. The officer also observed an open bottle of tequila in the driver's seat back pocket, and the defendant admitted to drinking. Standard field sobriety tests were performed, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The DIC was red and the defendant consented to breath. The results were 0.141 and 0.130.
Okay. Are you trying to tell me that he's consuming alcohol while he's driving?
There's no indications that it was in the pocket behind the driver's seat.
I see. All right. Mr. Herrera, I'm going to find that there's probable cause to go forward with the case. Tell me, how old are you, sir?
No.
What do you do for a living? I see that you have a lawyer, correct?
Right.
Okay. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, I do.
He's eligible, Your Honor.
You have liability insurance in your name.
Of course.
You have car insurance. All right. Good. Good job. So I'm going to have you sign a release. Victoria will have you meet with Felicia for your bond conditions, and then we'll just have you take a seat and wait for your lawyer to arrive. Okay? Please.
Johnson, page 19. Moesha.
Good morning, Ms. Johnson. Ma'am, you were charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir. The officer was dispatched to a service in Harris County, Texas. The complainant and the first witness, the complainant's mother, stated that the defendant had been texting and posting on Instagram about wanting to fight the complainant. The complainant and defendant were inside an apartment when the fight began. The witness stated that she observed the defendant to have a small sharp blade in between her knuckles when hitting the complainant. The defendant punched the complainant in the face, causing lacerations and pain. The defendant told the officers that the complainant believed that defendant was with the complainant's ex-boyfriend, which is what started the fight.
And it's just an assault?
Yes, Judge.
Johnson, I'm going to find that there's probable cause to go forward with the case. I'm shocked that it's not an aggravated assault. Let me tell you, I'm ordering you now as a condition of your bond not to be in possession of any weapons and not to have contact with the complaining witness in this case. Do you understand? Yes or no?
Yes.
I want you to understand that I'm going to do everything in my power to protect the public and every single person in it. And if that means locking you up and putting the bond extremely high, I will do it in a heartbeat. Do you understand?
Yes.
We're going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it and then you'll be on your way. Do not have contact with this complaining witness. Do you understand, ma'am? No more warnings. You will get no more warnings from us.
Next judge is page 20. Jones, DeMarcus.
Good morning, Mr. Jones. Sir, you are charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, officer conducted a traffic stop on the defendant's vehicle after observing it to fail to signal when changing lanes. Upon contact with the vehicle, the officer observed a strong odor of marijuana. The defendant was the driver of the vehicle, and there were 3 other occupants. A PC search of the vehicle revealed 2 bags containing 31.33 grams of marijuana within the reach of defendant's wingspan. The 3 other occupants of the vehicle denied ownership of the marijuana.
He's in the box. Yeah, if you want to take him out, I haven't done probable cause, so we need him. Just don't. Yeah, you can take him out, but just bring him back. Okay, Mr. Jones, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license, sir? You are not allowed to drive. I don't care what your reason is. I don't care where you're going. I don't care what you have to do. Mother Teresa needs to ride to church. I don't care. Do not drive. You will be signing an affidavit with me today, promising me you're not going to drive. Do you understand? You can be facing an additional 6 months in jail and a $500 fine every time you drive. Don't do it. Here's the other kicker. You're on bond for a felony theft case. It's very possible with this new case that you picked up, they revoke the bond and issue a felony warrant.
So, take your hood off.
All right, Mr. Jones, I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria. We're going to have you sign a reset. After that.
Okay, pause right here. This is a classic probable cause battle. The defense is arguing CBD, not marijuana, and unopened vacuum-sealed packs at that. But the judge is laser-focused on the smell, which legally is enough to trigger a search in many jurisdictions. What do you think? Should the smell...
You'll get out of here. When you come back, please have a lawyer, sir.
All right, Judge, page 20 and 21. Jones, Jared.
Raise your right hand. I'm fine, I'm gonna have you know taking under control. Okay, you can put the lady in the middle.
Jared Jones. Mr. Jones, you're charged with assault, bodily injury. You're also charged with criminal mischief. On the assault, you're facing a year in jail and or a $4,000 fine. And on the criminal mischief, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 23rd, 2024, officers were dispatched to an assault injury report call at a residence in Harris County, Texas. Upon arrival, the officers met with the complainant, who stated the defendant was watching her kids. When the complainant went to pick up her kids and went to the witness's house, the defendant became angry. The complainant did not take him. The complainant stated that when the defendant had arrived at the witness's residence, he was taking off his clothes in the driveway, trying to fight her. The defendant then approached her motor vehicle and struck it with his right arm, breaking her passenger front window, costing approximately $200 to repair. After the complainant pushed the defendant away from her vehicle, the defendant began striking her in the face with a closed fist 5 times. The complainant stated she felt pain, and the officer observed the complainant's rear or front passenger window to be shattered and observed the defendant's right forearm to have a minor incision from the glass of the window.
Mr. Jones, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with this person. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of any weapons.
Yes, sir.
What is the relationship between these two? Do you know, Alex?
Let me see.
So, Mr. Jones, we are going to reset your case to give you time to hire a lawyer. I will first have you go to Victoria, sign a reset. I'm then going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be on your way. You already have 2 cases now. Don't pick up a third. If I find that you're a danger to my public, I'm going to put you in jail. You will not get more PR bonds. Do you understand, sir?
Your Honor, they're just friends.
All right, come on. Can you file no contact and no weapons charge?
Lockridge, page 24.
Okay. All right, good morning, Mr. Lockridge.
Hey.
So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 20th, 2024, the officer was dispatched to a group home in Harris County, Texas. Upon arrival, the officer spoke with the complainant, who advised that after her and the defendant, another resident of the home, got into a verbal argument, the defendant told him, "I'm going to fuck you up." The complainant stated the defendant then went outside, grabbed a bed frame, and stated he would tear this place up. The complainant advised he was not in fear, but advised he would like to pursue charges because he perceived the statement as a threat.
He's not in fear.
Yes.
You know? All right. I'm going to find no probable cause on your case, Mr. Lockridge, but be careful.
Yes.
You know, when you get upset and you say things that you really don't mean, they can get you in a lot of trouble, right? Have patience. It's not hard. And if you get upset, walk away, find another release. But sticks and stones may bring you back to us, and you don't want to come back here. All right? Okay, man, just take a seat for me, okay?
We'll
Please.
dismiss it, Judge.
Please.
Next judge is Escobar Tobar, page 13.
So I was, come on up. I was gonna do a deeper dive on it to see whether there's probable cause. It's first time I've seen something like this.
Yeah, same here, Judge.
Do you mind do you have somewhere else to go?
I do.
Can you go do that and just come back maybe
Yes,
in
sir.
like an hour? Let me blow through all the arraignments and then
No
we'll sit.
problem. I'm gonna just let my client know and I'll be right back.
Yeah, I mean, I want to open the code. Let's go through it and take time, you know? Yeah, okay, sure.
All right, Judge.
Um,
Counsel, do you have an arraignment? Okay. Page
I know who
25.
you're here on.
McAlpin?
But I'd like to do the arraignments real quick, then I'll help you out.
Straight House, 25. McAlpin, Straight House?
Mr. McAlpin, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, the officer was dispatched to a residence in Harris County, Texas, in reference to an indecent exposure call. And upon arrival, the officer met with the complainant, who stated that he observed the defendant inside his property without pants and underwear on. The complainant stated that he observed the defendant dry hump the air and roll around on the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be open and observed his credit card missing and his in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Trespass of what?
Yeah, let's let Your Honor.
Is it house? Is it car? Did I miss something?
Your Honor, just pled as being on the property. It doesn't specify if it was a vehicle, so. The complaint just stated that the defendant was inside his property area.
Was there prior notice of him not to be there? Or, because I didn't hear you say anything about prior notice. I didn't hear anything about you saying.
Your Honor, it was just a residence, and in the case of a residence, notice is presumed, and he was.
No, we don't presume anything in the law, you know? I mean, we don't go based on hunches and read it to me again, please.
Yes, Your Honor. On November 24th, 2024, officer was dispatched to a residence in Harris County, Texas, in response to indecent exposure. The complainant stated he observed the defendant inside of his property without pants and underwear on. The complainant stated he observed the defendant dry hump the air and roll around in the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be open and observed the credit card missing and in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Yeah, I mean, there's no prior notice that he's not supposed to be there. You didn't say anything. You didn't say anything about he's
There's
trying
no
to.
statement as to without permission. The only thing is it is a residence, a residential area, Your Honor.
All right, I'm not going to find probable cause to go forward, Mr. McAlpin, but you're on notice now. If you go back to this place, they're going to probably arrest you. Do not go back to this place. Watch out what you're doing. You're on felony deferred for a very serious crime that can give you 10 years in prison. Do you understand?
Yes, sir.
Behave yourself in the free world, and if you cannot, you're going to end up possibly 10 years. You understand?
Yes, sir, Your Honor.
Take a seat.
Thank you.
Hila Bedoy, page 26.
Hold on a second. I'm waiting for Mark. So just take a seat for me and we'll be back with you here shortly, okay?
All right, Judge.
Hey, wait, Vic.
Page 30, Perez.
Okay.
Thank you, Judge.
You done already?
Yes, I appreciate that.
Quick.
Thank you very much.
Sure, of course. You are Marcos Perez. Mr. Perez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Is his last name spelled correctly with an S at the end, or should
Yes,
it be a
Judge.
Z? S is correct?
Yes.
All right, please, Alex.
One moment, here. Let me pull up the correct Perez. Okay. On November 23rd, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane of traffic and almost strike other motorists. Upon contact with the defendant, the officer observed a moderate odor of alcoholic beverages. The defendant admitted to drinking 2 alcoholic beverages. Stanfield's sobriety tests were performed. HGN 4 out of 6, walk and turn 3 out of 8, 1 leg stand 2 out of 4. The DIC was read and the defendant consented to arrest. The results were .094 and .089.
Any priority to be honest?
No, Your Honor.
Mr. Perez, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen? Are you in this country with or without permission?
No.
You're not in this country with permission? What happens if you go to jail? Don't tell him, Marcos.
Familia, esposa y 2 hijos.
I have a family, wife, and 2 daughters.
I don't care if Jesus lives with you, Mr. Perez. If you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put an immigration detainer on you and you will be stuck in custody until this case is over with and then shipped off to immigration. If you do not want that to happen, do not violate these conditions. I'm putting conditions on your bond now. If you violate these conditions, I will put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. It takes a while to resolve this case and then shipped off to immigration where you'll sit for another 6 to 9 months. I'm ordering you now as a condition of your bond not to drive. If you do not have a Texas driver license and you do not have liability insurance, do not drive. Do you understand? I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You have a lawyer. Good job on having a lawyer. It is your responsibility to stay in touch with Mr. Adroge. He will tell you when you have to come back to court. If he tells me he cannot get a hold of you, likewise, we will issue a warrant for your arrest. Do you have any questions, Mr. Perez?
Sir.
I'm not asking much from you. I'm just asking you to follow the law. And if you can't, or if you come a danger to my community, I will do everything in my power to protect it. I will have you come up here, swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a reset. After that, you'll get with Felicia for your bond conditions. And after that, you guys are free to go.
Thank you, Judge. Appreciate it.
Good luck, guys.
Pat, Joshua, page 30.
Joshua Pack.
Sir.
Good morning, sir. So you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. There's a co-defendant in this case.
Yes, Judge. And
Stop. Just don't say anything. I know tensions run high. Just,
and the co-defendant, it has an evading in court 13.
do you have the cause number on that one?
Yes, Judge. One
What is
moment. Cause number is 253-9856.
Okay, so it looks like we've got the lower cause number. Did you get it? No, that's not right. Let me see.
It should be a JV on dates.
Okay, no, I didn't.
Yeah, it's 253-9856. So it looks like we got it. Okay. So, Mr. Pack, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, please.
On November 21st, 2024, the officer observed the co-defendant loitering at a gas station, not conducting legal business while on proactive patrol of the area, known to have frequent narcotics trafficking and gang activity in Harris County, Texas. The officer observed the co-defendant grabbing the waistband of his pants and clutching what appeared to be a pistol, and the officer approached the co-defendant and the occupant of the motor vehicle he was speaking to, informed the co-defendant he was going to be pat down. The co-defendant then evaded on foot for approximately 0.25 miles, where he was eventually detained. The defendant then ran up to the scene and was yelling at the officer, acting irate. The officer repeatedly had to instruct the defendant to give space for the investigation, and the defendant followed the officer on foot as the officer walked the co-defendant back to the gas station. The officer observed on surveillance the defendant to be carrying what appeared to be a handgun in his waistband and clutching it before passing it to another male. The officer went to pat down the defendant to ensure he was not still armed, and the defendant pulled his body away, stepped away, flailed his arms, and tensed his body. The officer was struck on the jaw by the defendant's flailing arms, and the officer performed a double leg takedown and instructed the defendant to stop resisting and give his arms. The defendant continued to tense his body and pull his arms away.
What was he under arrest for?
So they were attempting to perform a search at the time, a pat down for weapons because they observed him to have a firearm on surveillance.
Okay. All right, Mr. Pack, I'm going to find that there's probable cause to go forward with the case. I'm going to do it with my pen. I'm not going to put any conditions on your bond. Just be careful out there. You know, really, you're on bond for another case now. It's very possible that they use this against you. Got to be careful out there. The only condition I want you to have is just don't have contact with the co-defendant in this case. Okay, that's it. What do you do for a living?
I'm a refer. I just quit my job from driving truck.
Why? Why'd you quit?
I just had a son. I spent my son was born on my birthday, November 22nd. I spent it in here.
How you making money?
I started my own holiday service.
Do you have an income now? Do you have an income now?
I have enough to sustain me. I will need a lawyer.
Can you afford one? Let's do this. I'll have you fill out an application. I want to take a look at your financials. Be honest. Don't just put zeros because I'm going to send it back to you. And then I'll take a look. Okay? All right, man. Do you mind giving me an application? Just give me a second.